Judge Aileen Cannon's courtroom is overflowing with unexplained filings, and nobody appears to know exactly what's going on. Roger Parloff of Lawfare pointed out the peculiar secret docket measures on Thursday, which had to do with the case of confidential information related to former President Donald Trump's Mar-a-Lago resort. The amount of undocketed filings in U.S. v. Trump MAL is increasing. The government requested authorization yesterday to file a surreply in relation to an undocked reply, which was linked to an undocked answer, which was related to an undocked motion, according to Parloff. This issue was brought up for the first time this year, and Parloff believes that Cannon's ignorance of the judicial filing system is the root of the problem. On February 6th, she prohibited parties from submitting sealed or redacted documents without first obtaining her consent, deviating from local rules. As they waited for Cannon to make decisions regarding redaction, the addies began transmitting undocketed documents to the court and each other. "Thus, here we are," he penned. "Why did she act in that way? She mistakenly believed that anything submitted with the court is presumed to be public knowledge, which is why I talk about the false perspective." Judge Cannon, who was personally nominated by the former President Donald Trump, has drawn criticism for a number of odd rulings that seem to have been made with the intention of favoring the former president in ways that other criminal defendants don't. For instance, following their confiscation from Mar-a-Lago, she had previously attempted to obtain classified information that the FBI was looking into for national security reasons. Lago handed them off to a special master so they could check if they were protected. Additionally, she is attempting to have Trump given access to witness material despite special counsel Jack Smith's warning that doing so could result in witness manipulation. Additionally, more than 3 years have passed since the attack on January 6th and the resignation of former President Donald Trump from office. According to MSNBC, a large number of rioters have been held responsible for their attack on the Capitol. However, far fewer powerful officials have been held accountable for their roles in arranging the anti-election conspiracy. There has been a lot of interest in the recent proceedings against John Eastman, and as NPR reported, the Republican attorney is now facing significant consequences. Due to his involvement in Donald Trump's legal bid to retain power following his loss in the 2020 presidential election, a California judge has publicly recommended that lawyer John Eastman lose his legal license. Former Supreme Court clerk for Justice Clarence Thomas, Eastman is well known in conservative legal circles. He was instrumental in creating and supporting a plan for states to send pro-Trump slates of electors to Congress in order to force then-Vice President Mike Pence to unilaterally halt or postpone the certification of Joe Biden's election victory. Judge Yvette Rowland of the California State Bar Court ruled that Eastman's misconduct constitutes exceptionally serious ethical violations warranting severe professional discipline. On January 6, 2021, Vice President Pence's authority to refuse to count or delay counting properly certified slates of electoral votes and the conduct of the 2020 presidential election, Eastman made multiple patently false and misleading statements in court filings, in public remarks heard by countless Americans and to others. On paper, at least, Eastman shouldn't have mattered all that much even after Trump lost. He was not employed by the White House counsel. The Attorney General wasn't him. Within the Justice Department, he lacked an office. As Chris Hayes of MSNBC recently put it, Eastman was a well-respected nutcase. But the radical lawyer did have one significant advantage. By late 2020, the U.S. president was eager to purchase Eastman's products, and everyone in the Trump entourage soon understood that the lawyer's opinions were with those of their employer.